As Taylor just said, I'm a partner here at the law firm. I've been practicing family court and matrimonial law, I think probably over 25 years at this point in time. So this is child support basics. And everyone has to realize that as far as basics go, we're going to go over the basic knowledge or information starting out. This is not a extensive CLE on all of the factors and things that you need to look at or unique child support cases. So we're going to start off with, where do you find the information that you need to start to prepare for child support cases? Family Court Act 413 or Domestic Relations Law 240. Now, I always tell everyone that I mentor or work with, if you read and understand Family Court Act 413 or Domestic Relations Law 240, you're way ahead understanding what child support is, how it is calculated, how to file petitions, what you need to do to move forward and file a petition with the family court, violations of court orders. I tell everyone to read that and understand it. Secondly, what we're going to talk about would be who pays child support. Okay, so when you file a child support petition, you find out who pays child support. The first thing you would look at is there a custodial order from a court regarding who has primary custody of the child? And that means where the child lives primarily throughout, let's just say, the week, okay? And let's just say there's a custodial order that sets forth that the child lives with one party during the week, and the other party has visitation or parenting time every other weekend. So right then and there, you can know that the child is living with the individual that has primary custody of the child. So who pays child support? In that case, the party who does not have the primary custody. Next step would be, do you have to have a custodial order in place to file for child support? You do not. In New York State, it's not a judge who determines child support. They're called support magistrates. They're the ones that hear all the cases for child support in family court. Of course, if you're in Supreme Court, then it would be the actual Supreme Court judge. And so when you would file your petition, if the parties, there's no custodial order, and we know that the child is a child of both parties, and that would be, involving a paternity test. Did both parties sign on the birth certificate of the child? And so you would file your petition in family court, and they're going to look at that. And even though there's no custody order, they're going to look at who is the child living with primarily. Again, it's the same thing as a custodial order, but there is no order in this case. It's just where the child is living primarily. And it would be the same concept where the child is living primarily, the other party would be paying child support to that person. Now, who else could possibly, you would have to pay child support to? Well, you could also have to pay child support to a grandparent if they have custody of the child. You would also possibly have to pay child support to the county. And usually what happens there is that if the parent or the individual who has custody of the child applies for services through the county, they're going to immediately ask to that person, do you know who the father is and who is the father? And then what will happen at that point in time is their position that before they determine what type of services they will provide to you, they're going to watch you, and the county can also file on their behalf to request child support be paid by the non-custodial parent to that party before they determine what type of services you can get. Now, everybody asks, and we'll talk about this a little later, well, we have 50-50 custody, I don't have to pay anything, correct? Well, that's not true, and we will discuss that later on. Next topic, failure to pay child support. The courts take this very seriously. And there's a number of things that can happen if you don't pay, and there's a lot of remedies and how you would file petitions. So let's say that there is a child support order in place. And remember, this is if there's a child support order in place, not if someone's voluntarily paying support. So let's just say that two parties agree that without even a court order, that one party is going to pay to the other party $100 a week. And then that party decides, well, I'm not going to pay you anymore. And then that individual then goes to court. Can they file a violation petition? No, they cannot. Can anything happen to that person? No, it cannot, because there's not a court order. Can that person attempt to retroactively get money back? No, they cannot. All right, so that's something you have to know, is that if it's voluntarily payments without any court order, you can't violate that person. You have to get a court order if you want to violate that person for non-payment of support. So what can happen? Now it says child support payments may be automatically withheld from the non-custodial parent's wages. So every time that you go to court, or if there is a court order, you have the right to have those wages withheld from the other party's income, paycheck, all right? The other party cannot disagree with it. They cannot object to it. The party who's collecting support has the right to do that, and it's called an income execution. What happens would be the child support collection unit would go ahead and send notice to the person's employer. They will inform that employer how much has to be taken out, and if there are arrears, how much has to be taken out. And that money then gets paid to the support collection unit. They then, at this point in time, they're usually giving out cards to the person who use support, and they put that into their account. If someone is getting direct pay under a court order, and all of a sudden they decide, well, I'd rather have it paid directly from his paycheck because he's not really on time, or she's not really on time paying, and they're a few days late every once in a while, and I don't want to have to go through that any longer. Do they have to go back to court? They do not. This is a right that that person has. They go to the child support collection unit, and they have to go to the collection unit, and they have to tell them that they now want to direct pay, and support collection unit will then institute and start the direct pay to that person. What else could happen? Tax returns, tax refunds. This is a big thing. So you file your tax returns, and let's say it's arrears. So they cannot take your tax return if you're paying your court-ordered support. They can only attach your tax return if you have arrears that have accumulated with regards to child support. And the only can do it, the child support collection can only do it. You as an individual cannot. So what would happen, the support collection unit would then go, and at the end of the year, attach your refund, and then that refund would be turned over to the support collection unit to help collect arrears. It happens a lot, and a lot of times people will call the office and just say, well, my tax returns are gone. Someone took my tax returns, and basically it's because if there's child support, and asking there's child support arrears, that's where it went, to go ahead and pay towards your arrears for child support. Another big thing, and it's happens a lot also, the person who's in arrears loses their driver's license. Now, child support collection unit will move to take someone's driver's license. Also, they can take professional license, fish and gaming license, but the biggest one that I see is driver's license. So they can move to take away your driver's license, and they don't have to do it by court order, they can take the license. Then what happens is the client calls you up and says, my license is gone. I can't work. I can't get back and forth to work. And I have arrears, I understand that. But how am I gonna, now pay child support if I can't get to work? That happens a lot. So what you do as an attorney, you would then go ahead, you have to file a petition with the family court judge, asking the judge to reinstate the driver's license, even if there are arrears due and owing, and setting forth that he needs his driver's license to work, to continue to attempt to pay child support. Maybe he's caught up paying, but there's still arrears. And most of the time, unless there's some drastic amount of money owed, and that person is paying some type of support, you're going to get it back from the judge. The judge does not want you not to have, the support magistrate doesn't want you not to have to go to work, not to pay your child support. Same thing with gaming licenses. Professional license is a big one. That normally is very drastic, but it does happen. So they can go ahead, they can take your professional license. I haven't seen it in my time practicing, never seen it done, but it is something that can happen. Assets may be seized, liens can be placed on property. So what that is, now if your arrears in child support, child support collection unit cannot just go out and seize your property or take your property to sell and then go ahead and get money from that to do child support. What happens here is that if someone files a violation of child support, and what could happen then is that you would go into court, there's a large amount of money owed, the judge can issue a judgment against that person, okay? And if that person who has the judgment for the arrears that are owed, if they then file it in the county that they live in, they can have someone execute that judgment to take property, bank accounts. All right. Now, what you're looking at here is non-custodial parent denied a passport based on delinquency of child support. That happens. Okay, not a lot, but it can happen. And what you need to know too is that if you're paying child support to the support collection unit and you go into arrears, the child support collection unit, even without the consent of the person who's receiving the money, has the option to bring you back to court for the violation. All right. Now, also with regards to the, if you're having your money paid through the support collection unit, they should, and I say should because there's times it doesn't happen, they're going to go to court and the judge, well, the support magistrate's going to have in front of him, okay, Mr. Belsky, I see that you have been making these payments, but your arrears on this amount of money, and they basically take that as it being true, okay? So then, if you're in court for a violation petition against you, then it really becomes your burden to show that that's not true or that you have been paying the money. But most of the support magistrate kind of take that as, you know, as this is what you owe. And it could be a big burden on you because lots of times maybe they didn't credit certain payments. So it's something to look at if you have a violation petition. Now, the big one, incarcerated for willful to pay child support court order. Now, willful and non-willful. Okay, this is something we have to look at. Non-willful means that you can show to the court that based upon my economic condition during this time, I could not earn money to pay it. I did not have the funds to pay it, but I understand that I'm in arrears. Non-willful means when you go into court, you didn't pay the money, and you have the means to pay the money. You have assets to pay the money, but you just decided that I'm not going to pay it. That is basically willful violation. All right. Now, lots of times in family court, if there are arrears and both parties agree that there's arrears, most of the time, even though it could be considered willful if you went to trial on this issue and everyone agrees, the court is going to make it a non-willful violation, that you did violate the court order, it's non-willful, and they'll set up some type of a payment or repayment program. Now, if the court said it is willful, what happens? Well, the court is going to set forth its findings of fact, and they're going to do a court order that this was a willful violation by this person not to pay their child support. The court is then going to set forth, the support magistrate is going to set forth, I believe that this person should be incarcerated for so many days based upon this willful violation. Now, the family court, the support magistrate cannot put you in jail. Then this file would be then sent to a family court judge. He would then hold a hearing. And at that hearing, it'll be determined if he should enforce the recommendation of the support magistrate, disregard the recommendation for jail, the support magistrate. And it really depends on the case. You have a right to present witnesses. You have a right to put forth additional any type of evidence to the judge. And then his final determination is going to be if he should go to jail, not go to jail. He's not going to change the willful to non-willful. he could say, well, we're gonna give you this amount of time to pay it back. And then if you don't pay it back or continue to pay, well, take that back. So you go to court, the judge finds, okay, it's willful. But what we're gonna do is, we're gonna find it willful, we're gonna set your arrears at X amount of dollars. And the order of this court is that you're gonna have to continue to pay on time your current support, and you're gonna have to continue to pay X amount of dollars towards your arrears. If you do not pay that amount of money on time, and if there is another violation that comes before me that you did not do that, I am then going to go back and institute this jail sentence on you. Judges do that a lot with willful violations. No judge wants to see anybody go to jail because then they can't pay the child support, they can't support the child. No one wants to see that. This usually happens when people are just do not care, they don't pay the money, and there's no reason not to pay the money. This is when this happens. And then legal fees. So last thing on this topic is legal fees. And when you look at legal fees, if there's a willful violation, the attorney for the person that brought the petition for their client, who is getting the support and the violation occurred from the other party, has a right to ask the court for legal fees because they had to bring this petition to the court. All right, we're going to go down to child support calculations. Yeah. So I'm going to, Kelly, can you skip to the next one, please? I want to talk about income first. Okay. The biggest thing always says, what is income? And I'm going to go back again is, what is income? Look at Family Court 413, Domestic Relations Law 240. It spells it out in detail. Everything you'll find is there. So, disability income, W-2 gross income. Remember that when you look at someone's income, it's not their taxable income, it is their gross income. So let's just say that I made $100 gross, but I put away into a tax-free 401k at my work $20. So then my taxable income is $80. That is not the income you use. You look at the gross total, which would be the $100. Your income, you get to take out taxes that you pay, insurance that you pay, retirement money. No, those calculations that come out of your check mean nothing. It's the gross income with no set off at that point in time. 1099 income, disability benefits, unemployment, Social Security benefits, pension benefits. These are just to name a few. Look at 413. It'll give you the full list of what income could be. All right. Quick example. Someone has their own business. They write off a lot of expenses and they say, well, geez, my income was only $100, but I grossed $2,000, okay? And then the court's gonna look at, what did you write off? And is it a real write-off, or are you paying yourself out of this business for car, gas, housing expenses, credit card payments that aren't business related, and you can go on and on and on. So the court's not just gonna step back and accept your tax return if you own your own business. They're gonna look at, and any good attorney is gonna look at, what are they writing off? That's very important. Now, what is imputed income? That comes up a lot. So, and it can also go along with termination or quitting your job. So lots of times people call me up and they say, geez, my spouse or the other parent, they don't like paying me my child support, so they told me I'm going to quit my job and go work for Burger King when they're making $50,000 a year. They can't do that, okay? You just can't quit your job just to reduce your child support. You can't just quit your job and then all of a sudden, well, I'm going to go and I'm making $50,000 a year as an executive. Now I'm going to go and do something, and I'll make $20,000 a year. You can't do that. That kind of goes hand in hand with imputed income. So what I mean by that is that the court's going to come in and they're going to say, this would even say if someone even lost their job, okay? They're going to come in, the court's going to say to you, they're going to ask about your background, they're going to ask about your job that you had, they're going to ask you about how long you've been out of work. Let's say for a month. Well, the question is going to become, how many resumes did you send out? How many interviews did you try to go on? How many places did you go around and put personal resumes in? Did you go to a headhunter? Did you go to any employment conventions or anything where they're seeking to employ people? Lots of times you find out that people say, well, I did send out resumes. All right, how did you send out? Well, this week I sent out 10. Did you go anywhere else? Did you go to employment agency? No. So my basic question to them is, did you get any jobs? The answer is no, no, I didn't get any offers. So then my next question to them is, okay, so you sent out 10 resumes. Did it take you 40 hours this week to send out 10 resumes? Well, of course it did. They're not doing it. They're sitting home doing nothing. They're not really looking for a job. They're not really out there pounding the pavement. And you'll get these answers a lot. Well, I put them on my computer and I sit there and I set them out to whatever the places where they send us your resumes, we'll put them out for you, or we'll go ahead and people are looking for jobs and we send them the resume. That could probably take them, you probably put out 10 resumes with a click of a button, okay? So the court's going to look at that, and they're going to look at that not too kindly. They're going to impute income to them with that case. All right, they're going to say, okay, well, you had this job making 50. You're not hurt. You're not injured. Okay, we're going to impute income to you based upon your education. And at this point, we're imputing income to you the $50,000 that you were making. They'll then enter a court order based upon that imputed income. And that person has to pay that child support. The support magistrates aren't going to care what you're making now. They're going to impute income to you. All right? Now, terminated employees. So you're terminated, which happens, and is it cause or not cause? So what that means is if you're terminated for cause, that means you did something wrong, okay? You got fired or terminated because you did something wrong, you violated a procedure, and you were terminated for cause. If you're terminated for cause, the court is not going to give you any type of a break. It's going to go back to imputing your income, okay? Just like you quit your job. If you were terminated because of downsizing and so forth, the court will again look at that. It's not your fault that you got terminated, but the court is going to ask you again to make sure that you're out there sending out resumes, try to get a job back, something that is up to your level of education, the amount of money you were making before, to look for child support. Would they give you some type of a temporary reduction in this type of case while you're looking? I've seen most of the time they will. All right, but when you come back, you better be able to tell the support magistrate, how, you know, what you're really doing and what you're trying to do to get a job. And again, when you're looking at this, same thing if one of the, say, someone didn't have a job. So, but really quick about your imputed income, someone didn't have a job and parties split up. And one of the parties is just sitting home and not doing anything. They say, well, I want child support. Kids are in school. I'm sitting home all day. I've been doing that. The court's going to say to that person, well, you know, you're going to have to look for employment. Okay, you're going to have to look for a job. You just can't stay home. And they could impute income to that person also. I've seen mostly at these type of things, they'll impute income based upon your 35, 40-hour work week based upon minimum wage is what they would do. And this could affect basically add-ons, which we'll talk about a little bit later. Kelly, can we go back to the child support calculations, please? All right, child support calculations. In New York State, as we know, basically has a statute that sets forth specifically child support calculations, how you figure it out, how much you have to pay per child. And again, where do you find this information? Family Court 413, domestic, I'm gonna keep harping on this, okay? Domestic Relations Law 240. All right, so what they do, they take your income, your gross income. Remember we talked about gross income before. And then they'll take away FICA, we call 0.0765 from that. They'll deduct that amount from your gross income. And that is the income that they will use child support calculations for. Now, what they do is they set forth that in New York State, just like it says here, one child is 17%, 2 is 25%, 3 is 29%, 4 is 31%. All right? And this is what the court goes by. All right? Then, calculation of child support. Now, we look here, the calculation is used until the limit of $183,000. And I'm going to talk about that in a second, but let's just go to the next slide, please. All right. So this is a basic calculation of child support. So we have the custodial parent's income, non-custodial parent's income. You take the total combined income, take away the 0.0765, and you come up with what is the AGI, the adjusted gross income of both parties. All right. Then you multiply that by how many kids, and here we use 17% one child. So you see that we have the adjusted gross income times 17%, and we have a total of 16,039. Now that is the total amount of child support that has to be paid, or that they address with. That's the total amount of child support before we start seeing who has to pay what. All right. So then, what we do is we see it's 16,039, and then the weekly support obligation, we have it right there, is $308 a week. Okay, so now we're at $308 a week, basic child support obligation. We're looking at both parents here. Then what we have to do, how do we figure out what portion of the child support has to be paid by what party? And what you would do is, first off, we would then go ahead, we would have to divide each parent's AGI income into the total amount of combined combined adjusted income. And then we come up with you have 40% of the child support obligation for one party, who is the party who makes the non-custodial more money, and then who is not the custodial parent, what their obligation should be. So basically what the court is saying here is that this is the total amount of money that we believe, based upon these incomes, that has to be paid by, contributed to the child for child support. Then they're going to say, based upon this though, the person who has custody of the child is not going to have to pay themselves, like we talked about earlier, who pays child support. What we look at now is then the non-custodial parent. This tells you that this person, the non-custodial parent, has to pay that amount of child support to the custodial parent. So when you look at that, what else does this kind of get you to? So also when you look at these percentages, so we look at this and 40% is one party, and then the other party is 60%, okay? What else does that affect regarding child support, those percentages? Those are important also because there's things called statutory add-ons. A statutory add-on under the Family Court Act is health care insurance for the child, out-of-pocket medical expenses for the child, daycare expenses for a child. Then what happens with these type of cases is that those percentages would apply to those add-ons. So let's just say, and this is above and beyond what you have to pay in child support. So let's just say that you have daycare expenses, $100 a week, that non-custodial parent is going to have to pay on top of their child support 60% of those. If the insurance cost that one party has for the child, let's say $100 a week, okay, that's divided 60%, 40%. Okay, so with those things, but keep in mind that lots of times here, that say if the non-custodial parent has the child support for the child in the other party's possession, what happens then? Well, what happens then, the party who is a custodial parent has to pay the non-custodial parent a portion of that expense. So let's just say at $100, the non-custodial parent, the custodial parent has to pay 40% at $40. So what happens then? Usually what will happen then is they'll take that $40 off of the party's child support amount that they're paying. That happens a lot, okay? So then what we move forward with here, and what are, again, we talked about statutory add-ons, all right? The next thing that we have to talk about is child support. And I'm going to go back to this statutory cap. So statutory cap, can you go back one, Taylor? No, keep going forward one. Okay. Statutory cap, that's a big thing. Now, what is a statutory cap? So the state, New York State, has determined that the statutory cap is $183,000. So you get to $183,000, and that the easiest way to figure this out, what I say, that the court has decided that if two parties' income equal $183,000, that should be really enough to provide for that child's, health, education, housing, those type of things. So anything below that, the courts are going to go along with what I just told you. The percentages, most likely they won't deviate from that, and they're going to go ahead and you're going to pay those amounts of money. Now, what happens next regarding, let's just say people make combined income $600,000. All right. Now, when you go above the statutory cap, you're going to argue, well, this should be paid above the statutory cap. Both parties' combined income is $600,000. And you're going to ask the judge, go above that cap. All right. Apply the Child Support Standards Act 17% to the income above that 183. The other party is going to argue to the judge, well, you shouldn't go above the 183 because there's no basis to do that. And what did the court look at? What do you argue? There's something called deviation factors. Deviation factors, there's 10 of them. I think there are 10 of them that look at Family Court Act 413 and DRL again. What can you deviate? How can you deviate? And the deviation factors, yeah, there's 9 of them. And they look at financial resources, health of the child, tax consequences, non-monetary contributions, the needs of the child. Things along this line that they look at. And if the court in this type of situation is going to deviate and go above, they have to set forth specifically why they did it based upon these statutory factors. And number 9 is a catch-all for these types of factors. And if they are going to below that 600 and just go to the 183, they again have to set forth why they deviated. If they do not do this, then that order could be overturned. All right. So if you're going to go and you're arguing a statutory cap case, you specifically want to make sure that you know what these factors are and argue them. Termination of child support. Can we get to that one?
Yeah, we're actually going to take a moment to read the first course code before we get to that. So on the screen, everybody will see the first course code, and I'm going to read it aloud. So that's going to be 628491. Again, that's 628491, and I'll leave that up on the screen for a moment for everybody to see.
You all set?
Yeah, we will move on now.
Okay, termination of child support. Also, I'm going to talk modification of support. So, termination of child support. Under New York State, person turns 21 years old. As soon as that child turns 21 years old, you have really no further obligation to support that child. All right? Now, can you agree upon supporting that child further above 21? If it's a mutual agreement, yes, you can. But 21 is an automatic, no more child support to be paid. By agreement. If you're doing a settlement agreement, or you do a separation settlement agreement or stipulation, you can determine by yourself when you're going to terminate child support or you're going to extend it. Lots of times people will extend it until the child, I shouldn't call it child, 21, finishes college. Okay. Next way, change of custody. Let's say all of a sudden that the child no longer resides with the primary custodial parent, decides to go and live with the other parent. That is a change of custody. Then you have to file to modify your child support based upon that child living with you. You also, if you want to get child support now from the other party, you need to file for a child support petition. Just because you're modifying doesn't mean you're going to get support. You have to file both. All right. Other emancipation factors. Child goes before 21, child goes into the Army. Child marries. You don't have to support the child. If your child marries, you don't have to support that child any longer. Child dies, of course. Either party dies, the payor, okay? Residence away from either party's home. So let's say that your 18-year-old child decides that they're gonna go live with their boyfriend and they're gonna get a full-time job and work. They're not gonna go to college. That again can be considered an emancipation event where you don't have to pay child support, okay? Now, remember, all these things you need to file a petition for, to modify it. And why I'm saying that is it's very key. If you have a child support order and some one of these termination events happen, let's just say you have a child support order and I am paying child support to the custodial parent, and I'm paying them $300 a week. Then my child comes to live with me. And the child comes living with me for 3 or 4 months, and they still take money out of my check because they didn't file a modification petition. I'm never going to get that money back. All right? It's more or less considered a gift to the other party. Okay? Remember that. And then I file a petition for child support 5 months later, and I say, well, now I filed for modification. I don't have to pay this party any longer, but the child's been living with me for 5 months. I want to go back 5 months, and I want that person to pay retroactive support. It's not going to happen, all right? The key is from the date you filed your petition forward, that is when you can terminate the support or ask for support. Anything prior to that, you're not going to get. Now, there's one thing here that it's something that came out recently. I'm just going to touch upon this disabled child. Okay, New York State now has changed and put in that if there's a disabled child above the age of 21, and that child is living with one of the parents, then child support can be extended until that child reaches the age of 26. I'm not going to go into this. It's very extensive what you have to show and prove, but just keep that in mind, right? We can move on. Drafting petitions. All right. So petitions, orders, stipulation. I'm just going to touch on this briefly. So we just talked about petitions. What type of petitions you want? You want modification petitions for child support. You want initial child support petition to get child support. You want violations petition to violate someone for not paying their child support. Those are really the 3 main ones that you have, all right? Now, stipulation and agreements. Remember, in stipulations or agreements, you can do anything that you want regarding child support. Say if 17% is $500 a week, you can agree it's going to be $300 a week. All right? You can say that child support is going to go to the child that is 19 or 18. All right? You can do, well, instead of statutory add-ons, let's agree that we're going to do 50-50. So remember that you can do whatever you want in an agreement regarding these things. And remember though, stipulations or agreements are basically a contract between you and the other party. Until that becomes a court order, you can't violate the person on an agreement. Okay, the court does not have to in any way give any credence to that agreement in setting support, because this is the contract between the two of you, and what the court says is you can't contract away the rights of your child, but if that becomes a court order, then it's something that's that will stand. All right. Now, also remember, in orders or stipulations, if there's let's say stipulation agreement, if you deviate from Child Support Standards Act in your stipulation, you have to set forth in that agreement or stipulation why you were deviating. You go back to look at your deviation factors and you put in there why you're deviating. Also, it's very important when you do your agreements or stipulations, you have to set forth and spell out in detail, like we looked at earlier, what both parties' incomes are. You have to actually put that right in there. Can you go back just for a second? A couple, keep going, right there. That you have to put in. You have to put that into your agreements, your stipulations. If you do not put that in your stipulations, that agreement, no matter what, is not binding. And if a court makes that a court order and that is not in there, then that court order is invalid. That has to be in your agreements. We've had a couple cases that we see where we have separation agreements come in, the judge didn't request this information, made child support or court order, we overturn that agreement. We have judges, support magistrates in this area that have failed to put that language into their court order. So they said, okay, we're ordering that you have to pay X amount of dollars, but they do not go through the calculation. Those orders are invalid, and then you can go back from all the way back, okay, to previous orders or when these parties separated. So that's very important that you put that in there. I think we have to do questions now. Is that right, Taylor?
Yeah, as long as you're all wrapped up with what you, or like the comments that you're on, before we open it up to questions, we're actually going to read the second course code. So that's going to be 746183. Again, that's 746183. And I'll leave that up on the screen for a moment for everybody to look at. If there's any additional questions that anybody has, please submit them via the chat so Mike can answer those.
Give me 1 second, Taylor, till I get to my WebEx site here.
Yeah, no problem.
Taylor, why don't you just read me the question? I'm having a problem getting on my WebEx. If you can read the question.
Yeah, absolutely. So the first one is going to be, are there any tricks to successfully challenge write-offs for self-employed parents to bring the income up?
Oh yeah, because lots of times, so to bring the income up, sure. Lots of times what you'll have is the basic is know a little bit about tax law, which is kind of a big thing. But yeah, look at what they're writing off that you yourself would have to pay for. Okay, you have to pay for your car payment. Okay, you have to pay for credit cards, food. You have to pay for they take somebody out. Kind of look at what you have to pay for as an individual personally, and look at what they're trying to write off. That's what they're going to look at. Okay, so tax law says that you can work out of your house and you can write off part of your mortgage. Well, you're going to have that mortgage anyway. All right, so you can't really use that as a write-off for your income. Okay, that's things like that. So take a look at those things. Okay, next, what do you got next, Taylor?
If the non-custodial parent wants to sign the child up for extracurricular activities, can he or she be reimbursed if the agreement is 40/60 pro rate for extracurriculars?
Well, what happens in that type of case? If you just do that without consulting the other parent and you just sign them up and say, now you owe me X amount of dollars, the argument is going to be in court that since you didn't go ahead and talk to me about this, I should not have to pay, any percentage of that because we don't know if I can financially capable to do that or not.
Are you good for the next question?
Yep, next question, please.
Is financial help from parents or siblings considered income?
It is. So if they're giving you money to live, it could be considered income. Yes, it can.
And another question along the same lines, how does the income of other household members impact support? For example, new spouse's income.
It does not impact support in any way whatsoever. It happens all the time where one party is making X amount of dollars and then they get married and then the other spouse is making $100,000. Does that get calculated anyway into child support? No, it does not.
If non-custodial parent owns properties, in parentheses, apartments, but is claiming them as a loss, does this still count as an asset/income?
What's going to happen at that point in time, they're going to look at your income stream from those apartments. And then it's going to go back again. Of course, you have to say you have $1,000 a month coming in, but your mortgage is $1,000 a month. Of course, that's not income. If you have, $1,000 coming in, you have a mortgage, you have insurance, you have different things to keep that taxes, you have things to keep that apartment running. Okay, you get to write those off. That will not be considered income. Any excess would be considered income, but remember, you have to look at what is going on with that. Are they trying to write something off that they shouldn't be writing off?
Next question is, can a family member who is also the caretaker receive child support payments? Also, in what circumstances do social services collect those payments?
Oh, so a caretaker?
Yeah, can a caretaker, can a family member who is also the caretaker receive child support payments?
I don't understand what caretaker means. Are they living with that person? That'd be a question. If they're living with that person, can that person then request child support? They can.
And then the second part to the question was, in what circumstances do social services collect those payments of child support?
Well, again, if you're looking at it really depends on who they are, caretaker. Are you then asking for the county to reimburse you for something? Are you looking for something as a caretaker to help pay for that individual? All right, that's the key there. If that's the case, then we talked about that. The caretaker is a whole different thing if you're looking at guardianship and those type of things. And it would take me a long time to discuss that, so I can't get into it. Go ahead.
Okay. Is there any way that after the child turns 18, support payments can be made directly to the child instead of the custodial parent?
No. You have to continue to pay to the custodial parent. All right. Now, unless, let's just do it this way, unless that child somehow emancipates itself from the parent, and then if that child basically asks you for child support directly to them, you can. But if all of a sudden the child turns 18 and I want to start paying my $100 a week to the child, mom or dad is gonna jump right in and file a violation petition against you.
All right, and then I believe there's just one more question. What if the custodial parent remarries and stops working, so he/she has no income? Could they seek more child support based upon having no income?
So the person, so read that again.
Hold on. What if the custodial non-married parent, oh wait, no, that's not the question. Sorry, one second. This keeps moving. What if the custodial parent remarries and stops working, so he/she has no income? Could they seek more child support based upon having no income?
No, it cannot.
Okay.
That's basically, you're doing that yourself, you stop working, you cannot do that. That's not gonna happen.
Can a child in school who also has a sitter after school hours can be an add-on? Can they be an add-on?
So if they're saying if a child has after-school programs, could that be an add-on if they have to pay for it? Well, again, is it they have to stay after, we don't know. Are they staying after school because they have issues in learning?
It's a sitter after school.
Oh, yes, sure, a babysitter, of course, a babysitter after school, of course, that's like daycare.
Okay, perfect. Okay, and then this should be the last one, unless any more are submitted. What is the advantage of setting aside a support order if it? Oh, sorry. What is the advantage of setting aside a support order if it was not properly specified as required?
Sure. Basic case we had was in Albany County. So what happened was that we represented the party that was seeking child support. We basically, this support order was in place for a couple of years. We finally went back and set it aside. So once you set aside a support order, okay, you can go all the way back to the previous order. So here we had a support order, say it was 5 years ago, and our client was seeking child support and said the party was working and they're only paying $50, say, a week. Okay, and then that order kept going and going and going, and then we went to court. We looked at this order previously and we said, you know, wait a second, okay, this isn't correct, all right? So that we want child support, and we overturned that order, set it aside, and then what happened was the party's income was really looked at the income that they was currently making at that point in time.
All right, and then another one is if the parents agreed to reduce an order because the child went to the military, is that enough to protect the non-custodial if a violation is filed later for failure to pay the amount stated in the order?
Yes, because remember, if you do not terminate child support and that person went into the military and it's an emancipation event, and you did not move to terminate that support, remember, you're in violation. Okay, you had to file and say, my child's emancipated, my child went into the military, I no longer have to pay support. Yes, you can be violated. I just saw a quick question. I want to answer this one quick question, okay? The question becomes is, the other party who's paying child support, it's remarried, then has a child with their current wife. Does that affect any effect on your income or paying child support? It does not, okay? You got to remember that. Now, sorry, one other thing I'm going to do about support orders, real quick, and we can wrap it up, is that if you are paying child support for a child that you're not going to court for, and you have a court order that says you have to pay X amount of dollars to that person, you get to deduct that previous court order child support away from your current income. All right, so that is an income deduction for you if you get brought into court by a current party who you have a child with and you have a previous court order for another child. You deduct that from your income.
Yes, thank you everyone for joining today's presentation, and thank you, Mike, for presenting. Please ensure that you complete and return your course evaluation and affirmation to CLE@tullylegal.com within 2 weeks to receive your certificate of attendance. Thank you, everyone, and I hope you have a good rest of your day.